misdemeanors, right? Just as a felony, I think it's 2 felony thefts, F5s.
Correct, yes.
Just asking for reasonable bond. Family is present, mother's present. She's had retained me about, I guess, 2-3 weeks ago, Judge. We have been discussing this. She's just ready to get these matters closed down. They are F5s, but we are respectfully satisfied with the misdemeanor bonds that have previously been set.
Your Honor, it looks like these are a number of thefts from stores in the Kenwood Town Center, and we'll be asking for stayaways from the Kenwood Town Center in general,
No objection.
specifically Lululemon, Nordstrom Rack, and Alo Yoga.
Mother too, TAB graduate, and she's working. Miss work yesterday, 32 years of age, the first few years of her entire family. So again, just asking for low bonds, Judge.
There's 1 prior felony, 1 violent misdemeanor, 18 prior misdemeanors, 5 prior failures to appear. On the felony theft, 19014, 10,000 anyway, plus EMD, plus stay away from Lululemon and Kenwood Mall. On the 19015 felony theft, 10,000 anyway, plus EMD. On the misdemeanor thefts, misdemeanors of the first degree, 5,000 anyway, plus EMD. On each count. How far does Miss Wright live from Kenwood Mall?
Your Honor, may it please the court, she's nowhere. We live in like Avondale community. Again, I respect the court's bond settings. The bonds, I believe, were 1,000 standard on the M1s initially. The family understands the EMD component. They were prepared to post a 1,000, 1,010% in the traffic matters. I don't think they go together, Judge, but again, she does not live anywhere near Kenwood Mall. No.
Yes, they are. These two will go, these two here. So yes. I missed that one. So, yes, I usually just try to put them where they need to. So they can separately. Yes.
Is the, I'm sorry, is the driving under suspension, is that unclassified?
Believe. Yes.
Would the court entertain a plea under the misdemeanor traffics? They're unclassified. I'm sorry for interrupting you, Judge.
What's the plea on the traffic?
Waive reading stipulates the language, pleas are guilty to the traffic.
All
Yes, Your Honor.
or any being dismissed? What level is the C?
Do you have that as the failure to title a motor vehicle?
Yeah, is that a minor?
I think it's a minor. I'm actually almost.
You could call your father that, actually.
I'm not asking that. It's true, the fact that I don't know, I would be like, what are you doing? It's a minor.
Apologies to the court.
It's a minor.
Ms. Wright, a guilty plea is a complete admission of guilt. The unauthorized license plates and the failure to title a motor vehicle are minor misdemeanors. Maximum possible penalty is a $150 fine plus cost. The driving under suspension, is that unclassified?
Yes.
Is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the 3 traffic offenses?
Yes, ma'am.
All right, Counselor already waived and stipulated. How long has Ms. Wright been in?
One night.
One, credit 1, remit the fines and costs. Is there anything else from anyone?
Grand jury report date.
Grand jury report date 1/16, January 16.
And that, so I understand the bonds on the misdemeanors are still 5,000.
Yes, so
Thank-
for the, yes, so for the record, the bond is higher than the standard
Yes, Your Honor.
bond because there are 18 prior misdemeanors.
Understood.
At least 8 I have counted are prior thefts in Ohio and outside of Ohio.
Absolutely.
And then there are the 5 prior failures to appear.
Appreciate you, Judge. Understand. I'll give it to you then.
Grand jury date January 16 on the felonies only.
Thank you.
Yep.
AC for, trial on the misdemeanor.
Yeah. Record people purposes. Biswap, Kadka Biswap. Request for an order of protection. In. Is there a Phenom Biswap? No response.
So Judge, Mr. Biswa is present. He does speak Nepalese, but I was able to communicate with him in English in the back. We do have an interpreter here.
Is the,
You feel comfortable talking, understanding? Okay. So
who's the interpreter?
he said if he doesn't understand something, he can ask the
Are you
interpreter.
Supreme Court certified?
Qualified.
All right, I I just need to swear you in. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment in accordance with the standards prescribed by law and follow all official guidelines established by the court for legal interpreting and discharge all of the solemn duties and obligations of legal interpretation and translation?
I do.
Thank you. All right,
Esteban, judge of the it'll be a not guilty plea on this matter. Esteban, Mr. Biswell is 40 years old. He has a risk assessment score of 0. He has 0 criminal history, obviously therefore 0 failures to appear. He's a high school graduate. He's got a really good job. He works at Sanmar Systems. He's in production there. He's been there for over 3 years. He did indicate to me that he can stay with at his brother's house. He didn't know the address offhand, but he could stay there if the court wants him to stay away. I don't believe we heard from the prosecuting witness. There was no response, but I would note in the 527, the prosecuting witness indicates that the reason she got a bruise was she fell in the shower, not any sort of indication that she was struck or hit by Mr. Biswell here. That being said, he is willing to stay away if the court wants that to happen. I would note that there appears to be several children on the protection order. I see one of them was potentially present. I don't see any reason for the other ones to be on there. So we would ask them to be stricken from the protection order.
from the state.
Your Honor, at this point, state would be objecting to any modifications in the protection order. The complainant in this matter is the 15-year-old child of the defendant and the prosecuting witness. Defendant and prosecuting witness are married, and according to the incident report that I have, the complainant indicated that the defendant punched her mother in the face. She witnessed this, and then the victim presented with visible injuries to her cheek and right eye when officers arrived on scene. State would be asking for no firearms as a condition of bond and execution of the temporary protection order. Say away, no contact from the prosecuting witness.
So at this time, I'm not taking the children off. We know the 15-year-old was there unless the 4-month-old was, both parents were at least at the house regardless of what happened. And then you have a 4-year-old. So I'm not taking the kids off.
Understood.
He's still signing.
Yes, he is willing to sign that, judge, and stay away from them. Given that, again, with the lack of history and the lack of any sort of cooperation, to say the least, we are asking the court to consider an OR or a very low bond.
10,000 anyway, plus jurors have requested no firearms.
This is an investigator, so there is no grand jury date. So that just goes down the file for Gina.
Do we want to go in there?
Look, it's lovely, and each of you do that. As long as they're close.
The one you handed me.
Thank you. They keep calling us bogus.
Lovelace. Lovelace.
Okay, I'll put it right. Okay.
Thank you.
Villarreal.
These are all city. All city traffic. As much as I can give them.
We're prepared to resolve this one.
Estamos preparados para resolver esto. Good morning, Your Honor. Rosemary Leite, certified Ohio Supreme Court interpreter.
So first to the county charge, the C-25 TRD 14209. We're prepared to resolve that one.
Is that a minor or an unclassified?
That is an unclassified.
All right. City charges.
It's my understanding that the 24 TRD 9030 will be dismissed. We are prepared to plead to the 25 TRD 9109, and then the 26 series will be dismissed.
The 26 series in its entirety.
Yes, that's my understanding.
And so one case is being dismissed. Is that correct?
It should be two with the city, the 24 and the 26.
The 24 TRD 9030, and what's the other one?
The 26 series,
Is being dismissed or
Yes.
he's pleading to?
dismissed. And just pleading to the 25 TRD 9109.
And then the county
And then the county,
14209.
yes.
Mr. Villarreal, a guilty plea is a complete admission of guilt. These are unclassified misdemeanors. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Excuse me, knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to 2 counts of driving without a license?
Guilty.
Counselor, do you waive and stipulate?
Yes.
Finding of guilty. He's been in one night.
Yes.
Yes.
Is there FRA compliance?
Not on the county.
Not on the city outlet.
Is there anything else from anyone?
No, Your
One, credit one, remit the fines and costs. Mr. Villarreal, at a certain point, and now you have 2 additional convictions. These go from unclassified misdemeanors to misdemeanors that carry jail time. So you need to think before you drive, because you do not have a license. Okay.
Campbell, Dante Campbell.
Your Honor, Dave Clodfelter on behalf of Dante Campbell, I'd waive his presence at this point in time. He is in custody, and my understanding is the jail did not bring him down. The sheriff's department did not bring him down today. This started off as a felony receiving with a bond of $10,000 at 10%, was indicted as a misdemeanor unauthorized use of a motor vehicle. I would ask if the court would consider using the bond. The plea is not guilty as referred to the assignment commissioner.
Has there been any Marcy's Law attempt?
At this point, Your Honor, I don't believe so. I don't have any notes to give a positive answer for that.
So I am not changing the bond because, one, because of Marcy's Law. Two, because of Mr. Campbell's record, which is 4 violent felonies, 12 felonies, 1 violent misdemeanor, 17 misdemeanors, and 6 prior failures. So the bond will remain the same. The traffic already has a OR.
It does.
Thank you.
Thank you.
Loveless,
Your Honor, on behalf of Mr. Lovelace, we waive probable cause. This is a felony which allegedly occurred in Blue Ash in November. He was in custody late December. I'm not sure why this case didn't show up then. Apparently it was filed yet today, but it occurred in November. He has holders for several other jurisdictions as well as a bond on the currently existing theft charges. We'd ask for a nominal bond.
anything from the state?
Your Honor, I believe the reason that the charges were filed is because, at least according to the complaint, labs came back positive for cocaine. My assumption would be that they were waiting on the lab before filing. I'm not sure otherwise. The state will be asking for a secured bond on this. No firearms as a condition due to the defendant's history and out-of-state holders. This was originally started off as a theft investigation from the target in Blue Ash. When officers began interacting with the defendant, he was displaying symptoms of drug use that caused them to call EMS to check him out. Search of his person revealed a number of baggies with suspected drugs, as well as a pipe with copper residue.
1,000 secured on each.
This is what Stevens said. Grand jury date, January 20, 120.
Meacham,
Thank you, Judge.
Cinnamon Roseman. Looks like she is here.
Oh, request for order of protection.
And I believe that the prosecuting witness is here, so we request to hear from her before dealing with the protection order. For the record, I'm submitting Kelly Leggett's designation. She already represents on another charge.
waive probable cause.
Yes, Judge. Well, yes, Judge.
Good morning, ma'am. What would you like to say?
Good morning. I don't want to move forward with the charges.
Speak up more in the box. Thank you.
I did want to move forward with the charges.
So once the case is filed, it becomes a state's case, so it won't be dismissed today. But are you concerned for your safety or the safety of any children?
No,
Has anyone threatened or coerced you to be here today?
no,
Do you want a protection order so that Mr. Meacham has to stay away from you during the pendency of the case?
no.
Thank you, ma'am. Is there a prior?
That's what I'm looking for.
Or is she correct?
Oh, yes, hold on.
I won't do the TPO at this time. The prosecuting witness does not want it. Based on what does the state want to add anything?
Your Honor, allegation is that the defendant struck the prosecuting witness in the face and arms, then pushed her face down on a bed and used his forearm to press her face into the mattress until she lost consciousness. Based on the nature of the allegations, understanding what the prosecuting witness is requesting, we are going to request a stay away and no firearms as a condition of bond. I don't have additional information at this time regarding the allegations.
I don't see prior, so at this point, probable cause is waived, but I'm treating it as a misdemeanor and setting bond without a prior because I don't see it. Again, I don't know what else would elevate it, but bond is OR plus EMD based on what the prosecuting witness has stated. I am, and the EMD is because there's 12 prior failures to appear. I am ordering a stay away during the pendency of the case.
Grand jury date, January
Thank you,
16, 1/16.
Thank you. Ichikawa. I know I butchered that. How do you pronounce it?
Ichikawa.
Oh.
Please not guilty, Judge.
Good morning. Good morning.
Morning, ma'am.
All right, as to bond.
As to bond, Mr. Ichikawa is currently being held on a $50,000 bond for a felony charge. He is unable to post that, so we would just be asking for a nominal on this.
From the state.
Your Honor, state will be requesting a secured bond on this juris if requested in case he does manage to post somehow. These are a number of letters sent from the Justice Center to the protected party at what is supposed to be a protected address. There have been 6 protection order violations since September of 2025, as well as 1 felony related to the same set of circumstances.
I'm sorry, it's not.
$5K secured plus juris if requested.
Stay misdemeanor, so no.
Soto.
Morning, Your Honor.
Good morning.
Andy Shingling appearing for the record. What had happened was Mr. Soto will be coming out. He was in front of Judge Stefano yesterday. He fired his public defender at that time. So I believe the judge put it in room A, hoping there would be a panel attorney in the misdemeanors. There is not. So I've explained to him what's going on. I'm going to represent him for the purpose of bond today, and then we will get a panel attorney assigned later.
Your Honor, I believe prosecuting witness is present. Anna Reynoso.
Yeah, I wanna be on something more. I wanna please, I wanna take it out everything for dinner. He my son, he no perfect son. He is good.
Speak up into the box.
I say, Ana Reynoso, he is my son, he no my person. I know what happened and he need help. I wanted everything going for him. I don't want to charge for nothing. I wanted my son, please. And if you need me looking some translator, I can explain better to you.
I don't think we have our translators.
I can also add, Your Honor, and I have seen paperwork.
Somebody is fine.
She has filed to terminate the protection order. It looks like that motion was filed on December 30th of 2025 and is set for a hearing on January 13th. So just adding that it looks like the underlying order will imminently be terminated as well.
What were the underlying charges for the protection order? Oh, this was in domestic relations.
Yeah,
That's correct.
it's a
This was just a
protection
CPO.
order.
There was no underlying.
And what's the relationship? Husband,
No, mother,
Mother.
son.
mother, son? Okay.
Given all of that, I would ask the court to consider an OR bond while this gets sorted out in court. He was working at Kroger, but his recent incarceration has caused him to lose that job.
Is there anything from the state? There appears to be no record as an adult or juvenile, one failure to appear for, traffic violation.
Your Honor, it appears that defendant was found inside the residence, inside his mother's residence. Claimed he was going in to retrieve some property. State will defer.
Was he in custody yesterday when he went in?
Yes, Your Honor. I believe he was taken into custody on the end of December. Correct? I believe it was December 29th is when he was taken into custody. The motion to terminate the underlying TPO or CPO was filed the 30th.
With the prosecuting witness present, with the motion to terminate file, no record, and just the one failure to appear, it appears that that was on this case, and then there have been no others on one of these cases. The bond will be OR.
Thank you, Your Honor.
Thanks. Valentine.
On a different chart.
Want to have Valentine?
Who's the attorney on
Valentine?
Who is it?
I think he's back there with an interpreter.
2, 3.
Now, we can go to shop, we can't find.
There he is. There you are.
Here it is. Okay. All right, Esteban.
As to bond, Your Honor, the plea is not guilty. As to bond, we would just be asking for a low nominal bond. There is a felony matter that is set for the 12th. So we would just ask for a nominal bond.
From the state.
We'll defer.
Into obstruction, 2,500 anyway.
Thank you.
Shaw.
Is there a Makia Shaw? Makia Shaw?
You, Ms. Shaw?
She is present.
All right. The deputy will check your ID in a minute.
Request for an order of protection.
Morning, Your Honor.
Good morning. All right. Yes, ma'am. What would you like to say if you were speaking to the box, please?
Yes, ma'am. I don't want to pursue the charges, and I don't need the TPO active.
Are you concerned for your safety or the safety of any children?
No, ma'am, I'm not.
Has anyone threatened or coerced you to be here today?
No, ma'am.
Thank you. Is there anything from the state? Ms. Shaw has no record, no failures to appear. The prosecuting witness is present.
We'll defer.
Or
Thank you, Your Honor.
can I have a return real quick?
So she also doesn't want returns.
Yeah.
So when they need that signed or they looking for them, they need to
Bless you.
to say, okay, we finished. And give it to the post
Judge will need this.
Okay. Well, you know.
Curry,
Ask the court to waive her appearance, Your Honor. Ms. Curry has a known history of mental health issues. In fact, last time she was in court, she was found incompetent and referred to probate. I had a chance to meet with her this morning. I will have to waive her appearance. She's in a wheelchair and very disoriented at this time. Given the nature of these offenses, I would have to continue this for prosecutorial review to Judge Mallory's mental health court docket on the 14th. You will need to make one change to the stamp. On that date, it's going to be at 11 a.m. I believe there's already KP's bonds in place.
There is the new charge, the public indecency.
I'll just ask for a nominal bond.
It'd be 1,000 anyway. And then 11 a.m. in front of Judge Mallory in room 240.
On the 14th, thank you, Your Honor.
Yes, thank you.
city DB docket.
Armstead.
Yeah, they're waiting on you.
Mr. Armstead. Judge, this is just set for bond revocation. Excuse me. Corbin Imes is already representing him on it, so I won't be designating, but to speak to Mr. Armstead, and we'll be addressing bond with him today.
All right, that's the bond.
So, Judge, I would just note that the allegation here is a violation of the EMU for several, excuse me, entering of the exclusion zones. Mr. Armstead acknowledges that he did enter the exclusion zone a couple times, but none of them were intentional violations. They were all basically brief while driving. He doesn't drive, so he has to take Ubers everywhere, especially during the holidays. He was taking his daughter to like some birthday parties and Christmas shopping and things like that. There was several times when he was driving on 75 with the Uber driver. He even told them one time, "You can't drive this way." They drove that way. He immediately called his EMU officer and explained the situation. He was never anywhere near the prosecuting witness. There was never any allegation that he was driving towards her house or anything like that. It was just technical violations, I guess, is the way I would explain it, and unintentional. So we are asking the court to consider reinstating the same bond. I've explained to him that he's got to be more careful and basically just can't leave the house if that's the way it has to be.
State.
Judge, it's on the plaintiff seems he violated the conditions numerous times by entering the exclusion zone on several dates in December. We would ask for the bond to be revoked.
How many more cases do you have on today? In here?
5 or so, I think 5 or so.
Let's recall this. Will you call Sam and give me a map? They'll give me a map of times and how it's gone through the exclusion zone. Because if it's a drive-through, that's different than if he was in the zone for a period of time.
Yeah, I can hang tight.
Okay.
Next, we can call Austin Betts.
20 seconds, 20 minutes. Betts. No, make sure your attorney's
More like 20 minutes.
okay. I wouldn't. They always ask how long. Like, 20 seconds.
All right, go ahead.
Hello, good morning.
All right, as to bond.
Judge, it'll be not guilty plea. As to bond, Mr. Betts here is 31 years old, lifelong resident of the area, does not live with the prosecuting witness. I would note, according to 527, he turned himself into the Justice Center yesterday when he found out about this. He's got a really good job. He works at virtual painting. He's been there for about 5 years. It's a little slow right now, but other than that, he does a really good job. He's got some college from UC, pretty minimal record, no felonies, only one failure to appear. Asking the court to consider an OR. Actually, could we call out for the prosecuting witness, perhaps?
Is Maya Williams present? You, Miss Williams? You have your ID on you? Yes, ma'am. What would you like to say? Nope, just talking to the box.
Kind of wanted to drop it. I want to do better.
So won't be dropped today. And it appears that the protection order is out of domestic relations court. So any modifications, you'll have to go back to that court. I can't modify any of those orders. As to this charge, are you concerned for your safety?
And Judge, for the record, I did explain to Mr. Betts that even if she was here, that would not get rid of the civil protection order, and he understands he still has to stay away from her.
It'll be an OR bond. There's only one prior failure to appear. And then to avoid this in the future, you all just need to go back to the order in court. All right? Thank you.
Next, Don Hollis. This is the two orders of protection requested. The Xander Colston.
Are they all the same?
Judge, I apologize.
Arnold.
Oh, are these from 13?
Yes. On that last one, that was just a straight OR, right? He was talking to me.
Yes, straight OR.
We're gonna get rid of the 2013 marijuana.
Yeah, yes.
Was he in prison in Kentucky?
He was for a brief time, Your Honor.
Oh. All right.
Judge, just to get this out of the way, the state, the city policy is dismissing the 2013 session of drug charge.
All right.
Thank you. No objection.
DRPA. The 17 cases.
So those will be not guilty pleas, Your Honor. As the bond judge,
Is this the first time these are being served?
yes. So there's obviously going to be some serious issues going on with these.
Anything from the state?
Defer to the court.
These are 2017 cases. There are 0 failures to appear. OR bond. Just make sure that you keep in touch with your attorney so you can make a court date, all right? Thank you, sir.
All right.
Jenkins.
Not guilty plea on behalf of Mr. Jenkins here.
As to is Lynette Allen present? All right.
So just upon Mr. Jenkins here is 43 years old, got a risk assessment score of just 1. He's got some college from Cincinnati State. He owns his own business, Opulence Cleaning and Landscaping. He's done that for like 8 years now. He's got pretty much zero record. It looks like just a misdemeanor charge and a minor misdemeanor charge as an adult and a couple minor misdemeanors as a juvenile. 0 failures to appear. Judge, without getting into the facts too much, I would just note it's our contention that this prosecuting witness is just essentially completely playing the system here. She has filed 3 different civil protection orders. All of them were different. He was actually down, as you can see in the 527, in room 585 to address that. He had proof of that. He had videos of her calling him, saying that she was going to keep filing these until he started dating her again. Obviously, we can't get into all of that here, but that is confirmed by the fact that he was down in room 585 to deal with this. He is adamant that he did not tell anyone to contact her, that he did not contact her. We are confident that the videos will show that, bear that out. He gave me the address to look that up on TikTok. He was just basically telling his side of the story. He is willing to stay away from her, obviously. I would very much prefer to stay away from her. We are asking the court to consider an OR.
Judge, briefly from the state, these seem to be stemming from social media posts that the defendant posted and then tend to have people contact the victim.
These appear to be from September. Mr. Jenkins has 1 misdemeanor, no other record, 0 failures to appear. It does not look like there was personal contact. It would be an OR, but the protection order is still in place, includes online. All right, thank you.
Strawbridge. There's an order of protection requested today. Demetrius Shields.
Are you Mr. Shields? Just take out your ID and come over here to the box.
So Strawbridge.
We will take care of it.
Not guilty plea on behalf of Ms. Strawbridge.
Yes, sir. What would you like to say if you were speaking to the box?
I'm not if you're already left moved out and everything. It's cool. It wasn't just drinking thing.
All right. Are you concerned for your safety?
No, ma'am. I moved out yesterday.
All right. Did anyone threaten or coerce you to be here today?
No, ma'am.
Do you want a protection order?
Yes, ma'am.
Ms. Strobridge?
You want a protection order?
Oh, no.
All right. So you don't want the court to order her to stay away from you?
No. I'm already gone.
Yeah, sorry. I think that was just a misunderstanding.
All right. Thank you, sir. Is there anything from the state? There's 1 prior violent misdemeanor. Looks like a DV in 2019 out of Florida.
Yes, Judge, we would still be asking for the stay away. Allegations are that Ms. Strawbridge punched the victim in the face.
The prosecuting witness is here, is not asking for anything. He's moved out, so I will order the stay away. I won't do a TPO, but you lost until the pendency of the case. It'll be OR plus the stay away. There are 0 failures to appear. Then I have some returns.
Quarters and a short recess.
Alan will be next, and EMP is coming over with me.
Oh, yeah. What is it? The bond revocation, she put a pause on, she went to that's that she'll wear it. As soon as they cross the ravine, yep, it tracks their location. Yep. It is like you track exactly where and when they reach That's usually the issue. So exclusion zone automatically is 2 months setup. It can be adjusted. Yeah. So a lot of the time we don't have once they're sitting on the highway, traffic through, you just happen to catch the piece of the highway that goes through the exclusion zone.
Court is back in session.
That's usually. Allen, Learis Allen.
Right up here, Mr. Allen. Good morning, Your Honor. Ben Rance for Learis Allen. The plea is not guilty. I would like to hear probable cause with regard to the discharge of the firearm.
Your Honor, started out as a traffic stop. Arrestee drove left of center and crossed double yellow lines. Failed to stop when lights and sirens were activated for that traffic stop. Sped up at a high rate of speed and committed various traffic violations. Caused numerous crashes and then attempted to flee on foot. Resisted arrest after being placed in custody by officers. Officers found 3 firearms concealed within the vehicle and, as well as in his possession. Defendant admitted to officers that the firearms were his and that he had fired them while driving.
Your Honor, first of all, I just want to address, the prosecutor said he caused several accidents. I believe it's almost caused. That's the paperwork that I have. I don't believe there were actually any accidents, but I could be wrong about that. But
That's correct.
regardless, I heard nothing that anything he did with regard to discharge of the firearm created a substantial risk. This charge is an M1 unless it does create a substantial risk of physical harm to somebody. When it is charged, when there is risk of substantial physical harm, it's an F3. That's how it's charged. But I would ask that the court grant an OR on that charge at least, considering there was no reading that the firing of the weapon caused a substantial physical risk of physical harm.
Per the complaint, the discharge occurred at East I-74 to North I-75, which would be a public highway. Discharging the firearm during operation of the vehicle at that location posed a substantial threat of physical harm to motorists on the highway.
The court does find probable cause. What was read was that there was a discharge of a firearm on a public road or highway, which almost caused multiple motor vehicle accidents. So for the purposes of finding probable cause to proceed, the fact that whatever occurred, the allegations that occurred almost caused several accidents on a highway. The court finds that there's probable cause that could create a substantial risk of physical harm. All right.
Your Honor, if I may, I believe the state stated that the near accidents, and this was my read of the facts as well, occurred well after that. The failing to comply is what almost caused the accidents. The discharge of a firearm, police were notified that it happened and then sought out Mr. Harris. The discharging is not what almost caused the accident.
Can you read again?
Yes. Arrestee drove left at double center, committing, crossing double yellow line multiple times, failed to stop when officers initiated lights and sirens, sped up at a higher rate of speed, continued making numerous traffic violations, including running stop signs and red lights and crossing over the double yellow. Arrestee almost caused numerous crashes, then attempted to flee on foot and had to be taken into custody under force, resisted arrest, even after being tased and given multiple commands. Firearms were recovered. Defendant admitted that the firearms were his and that he had fired the weapon while driving on the highway.
The double yellow line and the stop signs would not have occurred on the highway.
How far does it say where? Where did the stop happen?
Where?
Was it like exit to the highway or is this a whole separate?
Location of offense is 1815 First Avenue.
1815, I'm sorry.
1815 First Avenue.
He's telling me that's in Price Hill, which is not, it's in the neighborhood of 74 and 75, but
Per the complaint, the discharge occurred at East I-74 and North I-75 at the interchange.
discharge of a firearm is a charge.
You don't have to
Okay,
argue anymore.
gotcha.
I don't disagree with you that these are two separate, the discharging of the firearm and the possible harm were unrelated in as much they might have been part of the same traffic stop, but discharging the firearm was not the cause of the almost accidents. So the court does not find probable cause for the felony. The court, it is a misdemeanor. The allegations meet the standard for a misdemeanor. They just don't meet the allegation for the heightened felony at this point. All right.
Thank you, Judge. With regard to bond, Mr. Allen just turned 22 yesterday. He lives with his grandmother. He does odd jobs doing cleaning services. His biggest concern, Judge, he's lived in the area his whole life. He graduated from Winton Woods High School, but his biggest concern about being in jail is that he's scheduled to move out of his apartment tomorrow. He wants to avoid an eviction on his record. He also has a dislocated thumb. Show him your arm. That's from a boxing injury. He does boxing at a gym in Millville, and he has physical therapy and some stitches need to be removed. So he's got some medical concerns that being in jail isn't going to help him with, obviously. We talked about the failures to appear. Your Honor, he had some transportation issues, and at least one of those was he was present at court. It was in room 240, and they capiased him, and he tried to get recited, or tried to get it recalled, but they made him get recited. So just ask you to take that into consideration. I have good contact information for him and his family. His record, I see one prior felony and a couple of misdemeanors, asking for reasonable bonds on these.
From the state.
VA notwithstanding, state will still request secured bonds on the B, C, and D. There were multiple weapons that were found in the vehicle. Obviously, this was a high-speed chase with officers that posed a threat to both the officers and the community as well as the defendant. We do believe that a high secured bond would be appropriate in this case on the BC&D charges.
On the A, because no probable cause was found, that's OR. On the traffic, OR. On the CCW, 10,000 anyway plus EMD. The improper handling, 10,000 anyway plus EMD. The failure to comply or fleeting and eluding, 25,000 secured plus EMD. The resisting, 5,000 anyway. The obstruction, 1,000 anyway.
Grand jury date, January 16, 1/16.
This is yours. Come back to
You
it.
want everything or just the?
Yes, all cases. I'm sorry.
And
Your Honor, on Rodney Anderson, I am submitting Terry Tranner's designation. The felony is appropriate for drug court. We'll waive probable cause.
Mr. Anderson has some felony records, looks like from a while ago. 0 prior failures to appear. There's 1 pending charge, which looks like it's a seatbelt violation. This is the F5 presumption of probation.
State will defer.
Supervised OR on the traffic.
Thank you, Judge.
Grand jury date, January 21st, 1/21.
121 is the next statement.
Coleman.
Robert Coleman.
Yeah.
Mr. Coleman. Thank you, Judge. Rich Wendell for Mr. Coleman. May we hear a reading relative to probable cause, please?
As to all offenses.
We have reviewed them, but if we may have a reading, I'd appreciate it.
Your Honor, as to probable cause, officers received information that the defendant, known by the nickname China, was selling narcotics from the Days Inn located in Sharonville, set up an undercover operation. They were already familiar with the defendant as this alias China. Set up an undercover operation to set up a controlled purchase at the Days Inn. The defendant did sell 1 ounce of methamphetamine for $175 and directed the undercover officer to meet with him in a parking lot of the Waffle House, also located in Sharonville on US Route 52. Unmarked police car appeared at the Waffle House. and maintained telephone contact with the defendant. Defendant arrived in a pickup truck that he indicated to the officer he would arrive in, and then made that controlled sale. Officers moved in and conducted the arrest, approached the truck, removed the defendant, observed a loaded Kel-Tec handgun positioned between the defendant's driver's seat and the passenger door, or excuse me, the defendant's seat and the passenger door, as well as 2 baggies with the substance that fell off of the defendant's lap. The plastic baggie contained individual packages of cocaine that was recovered from his pants pocket. Additionally, a quantity of methamphetamine was recovered from the defendant's underwear inside the Justice Center.
Thank you, Judge. We'll submit on that.
Probable cause demonstrated. Esteban.
Judge, thank you. It's my understanding, Mr. Coleman, there's an indication that he does have a PRC holder. He does have a stable Hamilton County residence. I would note that. We would request fair and reasonable bond.
From the state.
State will request no firearms and high secured bond in this case. Defendant does have a history which includes aggravated drug possession. Sharonville police are familiar with the defendant as a frequent seller within their jurisdiction. So state will request a high bond in this case.
There's 1 prior violent felony, 14 felonies, 1 violent misdemeanor, 18 misdemeanors, 12 prior failures to appear. It appears there is an APA holder, and Mr. Coleman was just released from the Ohio Penitentiary in October of 2025. The CCW 25,000 anyway. The having weapons under disability 25,000 secured. The improper handling 10,000 anyway. The trafficking, what level is that at F3?
The decharge owner. Yeah, F3.
15,000 secured. The possession, 10,000 secured. Possessing a defaced firearm is a misdemeanor. 5,000, anyway. Thank you.
Grand jury date is January 16, 1/16.
Couch.
Verdict, Tyler. Ben Rains for Tyler Couch. Your Honor, the plea is not guilty. Will waive probable cause. Stand right next to me.
Is Terry Ann Hammonds present?
Your Honor, Mr. Couch is 27 years old. I see the only thing on his record is a jaywalking ticket. Is an ORAS score of 2. That ORAS score, that only other point from ORAS is based on part-time work instead of full-time work. He does work part-time, but he's been at Waffle House for 8 years. He's a cook there, so it's very consistent. I'd ask the court to consider that when setting bond. Like I said, no meaningful record. He's working right now. He lives with his grandmother, dad, and brother up in Coleraine. Your Honor, he adamantly denies these charges. The allegations are this occurred on January 4th. They were together on January 4th, also together on January 5th, and were on good terms when they FaceTimed before bed when Mr. Couch went to sleep early in the morning on January 6th, and he woke up on January 6th to yesterday in the afternoon to police at his home. Again, he denies these charges. Any marks on her neck were caused by his mouth. They were hickeys. He does believe her grandmother probably saw those and got upset, and that is sort of the basis of these charges. Based on his record and those facts, I would ask the court for an OR bond. He can make some bond, but he is concerned about losing his job. So I'll submit on that, Judge.
She is here. Good morning, ma'am. If you would speak into the box, what would you like to say? Just speak into the box. Is there anything you wanted to say? Are you concerned for your safety? Are you concerned for the safety of any children that you all may have? Do you want him to stay away from you? Did anyone threaten or coerce you to be here today? And are you saying you just don't want him, that you just don't not want him to stay away from you, or this did not happen?
It did happen.
You said it did? All right. Thank you.
Your Honor, state is going to request to stay away, no contact from the prosecuting witness during the pendency of the case, no firearms as a condition of bond, and EFD. This was an allegation that the defendant placed his hands around the prosecuting witness's throat and strangled her strangled her, causing visible injury. The prosecuting witness did report to the Coleraine Police Department, I believe 2 days after the alleged incident, at which point the injuries to her neck were still visible and observed by officers as noted in the complaint. She indicated that the reason that she did not report this sooner was that she was scared of what the defendant would do after the officers left. So she did eventually go in and make the report. Like I said, injuries were still visible, and she identified the defendant as the perpetrator at the police station. So based on the nature of the allegations, I do have a concern for the victim's safety while the case is pending. So we will ask for EMD, no firearms.
Ms. Hammonds, can you come back up? I'm sorry, I forgot to ask you this. Do you want Juris Monitor? It's like an electronic monitoring, and if he comes within 3 miles, he's not permitted within 3 miles of your home.
Yeah.
Okay, thank you. If you hang on, they'll tell you where to go so you can get everything set up, okay? Thank you. As was stated, as an adult, there's no record, no failures to appear. The strangulation, 15,000 anyway, plus juris if requested, and then the assault, 10,000 anyway, plus juris.
Grand jury date, January 16, 1/16, both cases.
Your Honor, would you be willing to make the juris open hours?
Yes.
Thank you. I'll come back and
As
talk
long
to
as
you.
he stays out of the zone, yes.
116?
Yes, January 16th, both cases. Dowdle, request for an order of protection. Is there Sierra Narid? No response.
For the record, Dan Might standing in for William Oswald. Mr. Oswald represents on a case that's currently before Judge Winkler. Judge will waive probable cause. As to bond, Your Honor, Mr. Dowdell denies the allegations. However, we talked about the possibility that there would be a request for a protection order, and he is able to stay with his sister on Queen City Avenue. I spoke with her this morning and verified that he could go stay there. I think pretrial also verified that. Judge, he is unemployed. Well, he's actually self-employed as a dog breeder, but the income right now is not very high. He can't afford a very high bond.
Yes, sir. Yes.
He is willing to execute the protection order, Your Honor. In light of that, we're asking for a low bond or an OR bond.
From the state.
Our state's going to request high secured bond, no firearms as a condition. Defendant is under disability. The prosecuting witness is a 6-year live-in girlfriend of the defendant. The allegation on the strangulation is that the defendant suffocated her until she passed out, after which point she woke up in the shower fully clothed with the shower running over her. During the time that she was unconscious, the defendant took her vehicle. Officers located him in that vehicle with 2 other occupants and took him into custody at that point. State has serious concerns for the safety of the prosecuting witness. She did express to officers that she was fearful for her safety. Obviously, the loss of consciousness indicates that this was more than just a hand around the neck. To the state, that is serious physical harm. So we're going to request no firearms, high secured bond, and juris.
It's my wife. This is my card. Yes. Can I speak to the judge?
Judge, with respect to the unauthorized use, he is telling me that it's his car. I had indicated that he denies the allegation.
It wasn't even open. It's my car. She gave me the keys and told me to leave. I left like the paper said. I came back and talked to my daughter, and it was just that. This is my car. This is my car. This is my vehicle. But it's cool you get, but this is my vehicle. Never left. She gave me the keys and told me to leave. I left. Went to my sister's house.
You don't have to talk about facts.
Yeah.
There are 17 prior felonies, 4 misdemeanors, 2 pending charges. 1 is a littering. So it's not serious.
She is going to give you EMD.
Yeah, that's cool.
There are 6 prior failures to appear on the unauthorized use of property, 1,000 anyway, plus stay away. The strangulation, 25,000 anyway, plus EMD, plus juris if requested. No firearms as a condition of bond.
Grand jury date, January 16, 1/16. Edwards, Travion Edwards.
Good morning. Good morning.
Good morning.
Yes, well, I guess I'll start. You waive probable cause?
No, Your Honor.
All right. Can you read probable cause?
Yes. Your Honor, allegations are that on December 29th, the defendant did, without permission, enter into the residence of the prosecuting witness, who is Markayla Baker. Entered into her home by kicking in the door and assaulting her. Allegations are that he dragged the victim out of a car, struck her in the face, picked her up, and then slammed her on the ground.
I don't think this is the right person.
Is this Travion Edwards?
Yeah.
Well, you don't say anything.
I know you are. We're just, is that what you're reading?
Give me 1 second, hold on.
Excuse me, Your Honor. My name is Ariana Hargrove.
Okay, just give me 1 second. We have to do probable cause and then I'll talk to you about the bond, all right?
This is Edwards, correct?
Travion Edwards, yes. While you're looking for that, I'm gonna go do the jurist on the other. Or do you have it?
I think so, Your Honor. I think they attached the defendants. Yep, they did. Attach the wrong paperwork. Okay, we're gonna back up. The wrong paperwork is attached to the cover sheet here. All right. Facts are, on or about December 31st, defendant did force entry into the residence of Ariana Hargrove, kicked in a locked door, causing damage to the door frame, and then made entry into the victim's apartment while the victim was occupying the structure, scratched the prosecuting witness on the neck, causing visible injury to the victim's neck.
And the reason why I want a probable cause read, Your Honor, is because the allegation is a trespass. Mr. Edwards lived there. That's where he was arrested for this charge yesterday. He lives with the prosecuting witness, so I don't get how you could trespass in your own residence. So that is why I wanted probable cause to be
So
read.
for purposes of probable cause, that is, the elements have been met. I think that is more of a factual dispute of the case, whether the state can prove the elements, not whether the complaint is sufficient to contain the elements.
Understood, Your Honor.
The probable cause is demonstrated. As to bond, yes, ma'am, what would you like to say?
I would like to drop the charges.
So they won't be dropped today. Once the state picks up the charges, it's the state's case. In regard to bond, are you concerned for your safety, the safety of any children?
No.
Do you want him to stay away from you?
No.
Alright. Whose residence is the particular apartment?
Mine.
And has anyone threatened or coerced you to be here today?
No.
Thank you.
As to bond, Your Honor, based off of what the prosecuting witness said, I'm not entirely sure that this will survive grand jury. We are going to be asking for an OR bond. Mr. Edwards cannot afford to pay any type of monetary bond. Mr. Edwards has been working extremely hard over these last 6 months to be able to get a job. He has been at Cincinnati Works. He's been there every week since November trying to get a job. He enrolled in their Jumpstart program, which takes place Tuesday through Thursday. He was actually set to graduate from that program tomorrow. He's trying to get his CDLs to be able to try to get a job where he can use his CDLs. He is currently working. He works for Track One, which is a delivery company, but he's trying to better himself career-wise. So he's been working extremely hard to get in the position where he's currently in with both his job that he has with Track One that he's worried about losing because that is a full-time job. And he was supposed to work today and he already is missing work by being here. So his job is already in jeopardy, as well as his graduation from the Cincinnati Works program is in jeopardy as well, since he is on track to be able to graduate from that program tomorrow. Like I said, Your Honor, it seems like the allegation here is a scratch regarding the assault. He denies these allegations tremendously. He was picked up at the residence with the prosecuting witness. Clearly, there haven't been any issues since this allegation, Your Honor. He can't afford to pay any monetary bond. He can stay away if the court wanted him to. His mom lives locally as well, so he does have a different address that he can go to while the case is pending. She lives off of Gaff Street, so we're asking for an OR bond or a supervised OR bond, Your Honor.
From the state will defer. Based on the facts, the prosecuting witness being present, I will say that the officers requested a high bond. But based on the facts of the case, the prosecuting witness being here, and when I say the facts of the case, just the facts that are part of the complaint, that any injury under the assault was a scratch. That is all that is on here that was visible to the officer was a scratch. The apartment was the prosecuting witness's apartment. She's here, does not want to go forward. Not sure what damage, if any, was caused to the door. There's not a criminal damaging that accompanies this charge. The bond, based on all of those things, will be a supervised OR. The PW is not asking for a stay away. There is not an allegation that he hit her. There's an allegation of a scratch. I'm not sure if, how, or what happened, but there's not an allegation that he actually struck her. So I'm not going to argue, or I'm sorry, I'm not going to order that. And there is no history of violence for Mr. Edwards in any of his history.
So SOR on both cases, Judge?
Yes.
Okay. Grand jury date, January 21st, 1/21.
Give me 1 second. You all can go. Just before we copy this.
Hold my voice, Supervisor.
As we go through cases, just go ahead. CPD. The past 5 years.
Give me
Court
1
is in a
second.
short recess.
Just right next to the. Yep. Thank you.
Are you giving us a grand jury date?
I'm sorry. On the last one? 1/21
Thank
on
you.
Edwards. I just don't understand why. Yeah. I don't understand why this stuff is not attached. So I think this is the stuff that comes up, because I'm gonna get these in city cases. So I think that this stuff came over. Because on Saturday this week, I get emails from Julie. And it usually has the stuff. It was so. No, she can go to. No, it's for the people who do Saturday one day, and they'll know what to do. So I usually get the incident reports. I can go see if I can find one. It's images. Saturday emails. Possibly, yeah. I don't know, I said I just got here, I don't know the exact functioning still. Or like how everything gets where it's supposed to be.
I pulled it in. I'm sorry. No, you were right there. I'm sorry.
I think it's.
This is just extra copies of Might change about hearings is once I get the paperwork from Jordan, I just bring it over here and put everything together here. Yeah, yeah, so that I can start attaching this stuff. Yeah. There's no point having the stuff over here. Yeah, well, and this is all of the complaints. Like this guy has 2 cases. This is the paperwork for both. Yeah. Yeah, so it's some duplicates, and then this has 527s, which I usually Shanice, do you have a staple remover up there?
A staple remover?
I have one. There you go.
Connor, well, you could have seen my face when you were reading this back. Yeah, Darcy was like,
And I was shaking my head no, saying I have no familiar.
What, is it
It's
your
just-
last name?
It's Baker. Yeah.
Except it wasn't, because that wasn't.
But then it was just funny too, because it was
Yeah, no. The next 2 of us. Yeah.
What's going on?
Yeah, feel free to just like huck things at me if that's happening. So sorry, meeting 1 o'clock. Yeah, prosecutors are having a meeting. So, that's not happening. Who's Jaleel Horton? What did we turn out Jaleel Horton? That's who.
Did the case already get called?
No, it's like 2 minutes.
I know. It's 28.
Bill had it right.
No, I'm serious.
You know why? It's gas.
Court is back in session.
We can recall,
He's right here.
okay, we can recall Armstead.
Scott, if you're ready. You're ready to react. All right, let's start. Come on, Armstead. Right here, man.
All right. So the court has contacted EMD because while Mr. Armstead should not be in the exclusion zone at all, that's the purpose of the jurors, the court understands that the way Cincinnati is set up, sometimes a highway will go through an exclusion zone, and our EMDs track that so that we know if someone is driving through or if they will ping at a location for an extended period of time. Mr. Armstead's assertion was that he was taking Ubers and he was driving through. The 12-1, Mr. Armstead was at an apartment building from 11:45 to 11:52 and specifically sent to the EMD unit were messages to get out of the zone now, beeps, leave zone now. On December 11th, he was the same place for 7 minutes. On December 21st, that was a drive-through. December 25th was 406 to 413 in the same building. The 5th was a drive-through. And then January 3rd, the 5th was at a 1129 to 1134 at, in the zone, but not in the same place as 1 through 4. And then the 6th was a drive-through to which EMD called and he said he was going to the mall. Is there anything else you want to say?
Judge, I spoke with Mr. Armstead. We were trying to figure out what that location was. I think it might have been a store that he went to.
At the apartment?
No, I asked him up on 8th Street. Tell me.
No, man, it's a liquor store, the corner store right there.
Did you just say a liquor store?
No, it's a corner store and liquor store together. Absolutely, I'll be going to the store.
Let your attorney talk, please. You're not helping yourself.
So yeah, we only had a brief moment to discuss it to try to figure out where he was going there. But I think he was going to the store there. Again, I would just note that he was nowhere near the prosecuting witness's house. Obviously, there was no intention of, the point of the exclusion zone and the jurist monitoring and the EMU is to protect the prosecuting witness. There was never any issues with that. It looked like he was just barely within the zone, within a tenth of a mile or so within the zone. He wasn't anywhere near her. A couple of them were just passing through. We are asking the court to just consider reinstating the jurist and be much more careful now.
Is there anything else from the state?
Nothing further from the state.
The initial bond was $5,000 plus EMD plus jurors. It was $5,000 anyway. That bond is revoked. The new bond set is $15,000 secured plus jurors. England.
Judge, thank you. Rich Wendell for Mr. England. We have reviewed the allegations of the complaint and would waive a formal reading relative to them. Your Honor, thank you. Judge, he does report a good, stable in-county residence. I believe 12 years at that residence. Reports recent employment as a mental health tech. I believe that information is on the pretrial bond sheet. I don't show any failures to appear on his record. We would, despite the nature of the allegations, request low bond in the matter in light of the good contacts. Thank you.
From the state.
Consider request no firearms as a condition of bond. I do see that the most recent contact, at least as far as county record, is a 2013 felonious assault with spec. With regards to the present case, this was initiated as a traffic stop. Officers did locate 256.71 grams of cocaine in the vehicle after that stop. Officers indicated that that was indicative of high-level drug trafficking. Your Honor, based on that, we will ask for a high-secured bond as well.
There's 2 prior violent felonies, 2 felonies, 5 misdemeanors, 0 failures to appear. These are for both felonies of the first degree. The improper signal or turn, OR. There is a bond request by officers for a high bond, providing the reasons, prior criminal history, the amount of drugs that were allegedly found on defendant. $25,000 secured on each count.
Grand jury report date is January 16, 1/16.
Horton,
You want it all, or just?
On both, yes.
Huh?
On both.
Okay.
Request for a temporary protection order.
Horton.
All right. Is there a Michaela Baker? Michaela Baker.
He's gonna sign the protection order, Your Honor. And the plea of not guilty, Your Honor, and we'll waive the reading and probable cause and address bond whenever the court's ready.
all right, that's fine.
My client's 22 years old, was a lifelong resident of Cincinnati. He was in the Army for 2 years and honorably discharged. He was a Woodward graduate. He has 2 children. Well, he has 1 child and then 1 on the way. He works at 2 different full-time jobs, one at New Path, which is a residential mental health facility that he's a behavioral health technician, and then also at DCCH doing similar work there. Your Honor, just ask you to take that consideration. He has no prior contacts that I have any information about, no failures to appear, or a score of 1. I have contacted Greg Street regarding the veterans issues. We would ask for an OR or supervised OR, Your Honor.
From the state.
Your Honor, state will ask for no firearms and a high secured bond. As to the domestic violence case, this is the paperwork that was attached to the previous matter. Allegations are that the defendant on December 24th did strike the prosecuting witness, Michaela Baker, in the face and slammed her on the ground, knowing that she is pregnant. He does currently have an infant child with the same person. Defendant pulled the prosecuting witness out of the vehicle, struck her in the face, and then slammed her onto the ground, causing injuries for which the prosecuting witness was self-transporting to Good Sam at the time that she contacted police. So state is going to ask for juris and a stay away. Understand he's executed the temporary protection order. We will also ask for no firearms as a condition of bond on that case. With regards to the 386 matter, this was initiated by a traffic stop. Defendant was an occupant in a vehicle that was occupied by multiple individuals. Canine search of the vehicle turned up a loaded 9mm Glock 26, as well as a loaded AR pistol. The defendant did state that he was aware both firearms were in the vehicle and identified them as his. The Glock pistol was stolen. So state will ask for high secured bond on those matters as well.
As was previously stated, there's no conviction records. The officer deferred to the prosecutor as to request of 0 failures to appear. There is a pending domestic violence and assault charge that is hanging out there against the who is the prosecutor witness in this case?
It's not the same on this case, my understanding. Her name,
Victim on the current DV is Michaela Baker.
Michaela, who I'm sorry.
Michaela Baker.
Okay. So yes, it's a different person than is the other DV case. the receiving stolen property, 5,000 anyway. The CCW, 1,000 anyway, improper handling, 1,000 anyway. The DV, 10,000 secure, plus jurors, plus no firearms.
Grand jury date January 16th, 1/16.
Kaiser,
For the record on Kaiser, Dan Might standing in for Thomas Maloney. Tom Maloney represents on a case that's before Judge Garing right now. We'll waive probable cause.
this is a F5. Mr. Kaiser has some record. It looks like this is personal use quantity. Is this going to drug court?
Judge, only because he already has Tom Maloney for some reason, that there's a case already before Judge Garing, so, although I agree with you that it's the kind of case that should be in drug court.
Stay with the first bond.
OREMD. I'll do open hours.
Thank you, Judge.
All right, McComas.
Grand jury dates January 16th.
We're going home, but we have to get the key, right?
Your Honor, for Mr. McComas, he was not brought down. He already has Brad Mormon on a case that's before Judge Cash. So I'm moving to waive his appearance. We're comfortable moving forward if the court is today. Oh, I didn't. Wait, is this Mr. McComas?
No, sorry.
Oh, okay.
Oh, okay. So we're still on McComas.
Okay. Are these related to the felonies?
The current, Judge, they happened on different dates. They're,
Okay.
Let's see. One of the pending felonies is on November 5th. This one is October 20th, so it's actually predates. He's been held since November 5th. So we're asking the court to set a reasonable bond. We're waiving probable cause.
Is there anything from the state?
Question first, stay away from Lowe's with the
1,000 anyway, plus state.
Thank you, Judge.
grand jury dates January 16, 1/16.
All right, Robinson.
Request for a temporary protection order. 2 temporary protection orders.
Standing in for Rick Swingle on this, Your Honor. It's just against.
For the record, I just got every on the unrelated misdemeanor probation violation.
It's a particular thing you can't go around for. You understand?
All right.
He's gonna sign the protective order, Your Honor. And then right there. When they're not guilty plea to Your Honor, and waive the reading of the probable cause.
All right, Esteban.
Yes, Your Honor. We're gonna finish signing this real quick, so you'll be able to listen. My client's 66 years old. He's a retired machinist, Your Honor. He turned himself in when he heard of the charges. He actually walked, I guess, down to the Hamilton County Justice Center to turn himself in. He does not have much of a record, or if any, it's not been recent, I believe. And his 2 failures to appear. He is not homeless, by the way. I think there was some reference to that. He lives with his sister, and he has a place to live separately on. He denies these charges. Just ask the court to take that consideration, set the bond.
From the state.
Your Honor, prosecuting witness on all cases is Alicia Bird. Officers were investigating the felonious assault in which it was alleged that the defendant struck Ms. Bird, which was a girlfriend, over the head with a brick hammer, according to the complaint. Also bit her fingers and pulled on her hair. The victim did have visible injuries and was transported to the hospital for serious bruising, as well as injuries to her scalp. During that investigation, the prosecuting witness also disclosed that earlier in the same day, the defendant forced her to travel to an ATM and withdraw $800 in U.S. currency and threatened to kill her if she did not. The prosecuting witness did believe that the defendant was in possession of a knife at that time, based on her knowledge that he carries a pocket knife on his person at all times and had previously threatened her with that same knife. Based on the allegations on these cases, Your Honor, state's going to request no firearms as a condition of bond. I'm going to request a high secure bond. We do believe he poses a safety risk to the prosecuting witness, as well as EMD and juris if requested.
There's 1 prior violent felony, 1 felony, 4 violent misdemeanors, 9 misdemeanors, 2 prior failures to appear. The TPOs have been executed, correct?
Yes.
The allegations include serious injury, and 1, the officer said that she was scalped. In the felonious assault allegation. On the robbery, 50,000 secured plus EMD plus juris. The felonious assault, 75,000 secured plus EMD plus juris. The DV, 25,000 secured plus EMD plus juris. The act menacing, 25,000 anyway plus EMD plus juris.
Grand jury date January 16th.
Judge
1/16,
Mallory
all
said-
cases.
Judge Mallory has set a $10,000 habeas fine. That'll remain the same. I don't change judges' fines. Sinclair.
What's the grand jury?
1/16.
Sinclair.
Sir, Ramaya English, Ramaya English.
Waiting probable cause.
Yes, Your Honor, there was a warrant in this case.
As to bond.
As to bond, Your Honor, there's a few things that I want to mention about Miss Sinclair. She's 35 years old. She's lived here in Cincinnati all of her life. She lives here with her 3 children. The oldest is 17 and the youngest is 3 years old. Miss Sinclair has 0 felonies on her record and 1 misdemeanor conviction. She has no convictions of violence. She has a very good job at UC Health. She cleans IV pumps there. She's had that job for about a year. She's also currently in school virtually working to get her GED. So she's doing a lot to both work and support her family, but also improve herself. As to the case itself, I do want to note that she turned herself in. If you look at the 527, it is warrant service, but the place of arrest is at the police station. So she did turn herself in on this case once she realized she had a warrant. We talked in the back, I know she has 7 failures to appear that are listed per pretrial, but she disputes that number. She's concerned. She had a couple cases where people were using her name and she's worried that that may have somehow affected it, but she turned herself in. She's not a flight risk. She will definitely come back to court. As to the charge itself, I don't want to get too much into the facts here, but I would note that the allegation here, it seems that it is an attempt to cause physical harm rather than actually causing physical harm. The allegation notes that the video shows a car driving towards the prosecuting witness, but it is only the prosecuting witness's statement that says that the car actually made any contact. Additionally, there's no mention of any injuries in the paperwork that I have. Any interaction that Ms. Sinclair has had with this prosecuting witness has been trying to get away from this prosecuting witness. In fact, Ms. Sinclair called the police regarding this prosecuting witness because Ms. Sinclair was actually shot at. So there's a lot going on in the actual allegations here, but I would note that there's no mention of physical harm. There's no mention of Ms. Sinclair having a gun or anything like that. She did turn herself in on this case and she has a minimal criminal record. So we are asking for a reasonable bond in this case. We discussed that she might be able to make a $5,000 at 10% bond.
The allegations are that the defendant did try to run over an ex-girlfriend. Prosecuting witnesses were Maya English with her vehicle. Multiple witnesses indicated to police that the defendant tried to use her car to run over Miss English and actually made contact twice with Miss English, at which point one of the other witnesses did draw a firearm and discharged it to protect the life of the person that was about to be hit by the vehicle. There is surveillance video. Officers indicated they were able to observe store surveillance that showed the defendant driving at a high rate of speed towards the victim, which was consistent with descriptions provided by the witnesses. Do believe that there is a risk to the safety of this individual as well as to the community here, Judge. We're going to ask for a high secured bond, no firearms as a condition of bond. As of this moment, I don't have any indication in the incident report as to the extent of the victim's injuries, if any.
All right. Is there anything about transport to the hospital or anything?
Not in my report, no.
There's, as was stated, 1 prior misdemeanor, 7 prior failures to appear. There is not, we don't know any indication of the possible, if any, injuries. $15,000 secured plus EMD plus jurors if requested.
Grand jury date, January 16.
Turner.
1/16.
Here. Okay, I'm gonna go talk to him right now. Yes.
We'll waive the reading the probable cause and enter not guilty plea, Your Honor. As to bond, my client is 31 years old, a lifelong resident of Cincinnati. He went to Euler High School. He has a GED. He was working at a Mannix Moving, but it slowed down once the weather got bad. Has 2 children, ages 8 and 4. One of them lives with you, is that right? He has 3 failures to appear in an ORA score of 4, Your Honor. He does have a few priors of this nature. I believe he has a fentanyl addiction issue, Your Honor. Just ask the court to take that consideration.
From the state.
The state will be asking for a stay away from Murray's drive-through located at 2191 Queen City Avenue. Allegations are that on 4 separate dates, defendant did gain entry to the business after hours using a screwdriver to pick the lock on the back door, took a substantial number of packs of cigarettes and was admitted to officers that he was selling them on the street to supplement his income. So we'll ask for a stay away in E&D based on prior failures to appear.
There are 4 prior felonies, 2 misdemeanors. I have 2 prior failures to appear. It looks like Mr. Turner was just released from prison, River City, in February of 2025. The officer requested a high bond, listing the reasons for the high bond request as criminal history, pending charges, and previous criminal convictions, specifically 3 prior convictions for the same offense within the last year. It looks like there was a B&E, breaking and entering, July of 24, July 24th, 24, June 18th of 24. I see the 2. $5,000 secured on each count, plus EMD with a 3-mile radius from Murray's.
Grand jury dates January 16, 1/16.
And stay away from Murray's.
Okay.
Vaughn, Samantha Vaughn.
Vaughn.
Is there a return or? Bring him out.
Right in the middle.
Sir Matthew Dargis.
Good morning, Your Honor. We'll waive probable cause.
As to bond.
Thank you. As to bond, a few things that I want to point out about Ms. Vaughn. She does have one pending case, but it is an F5 possession of drugs that I do represent her on currently. These charges are also F4s and F5s. They are nonviolent. Ms. Vaughn has 0 felony convictions and 6 misdemeanor convictions. She has nothing of violence on her record. She does have a good address and she does have a good phone number. She has a mother who lives in Warren County who's currently supporting her children. I am going to do a social work referral for Ms. Vaughn to try to possibly get her into a program that will support her and help her as these cases are pending. These are low-level offenses. I would ask Your Honor to maybe consider OREMU so that we could possibly get her to a residential treatment center.
From the state.
Your Honor, this is a 2010 Audi registered to a Matthew Dargis. The owner reported that the defendant took the keys without permission and took the vehicle without returning it. She was located in the vehicle with another individual, and that's when they discovered the drugs on her person. We asked for EMD based on history here. I do see contacts for theft as well as drug offenses.
There were 6 misdemeanors, 1 pending charge for possession of cocaine, 3 prior failures to appear. These are F5s for the possession, then a misdemeanor for the unauthorized use, and then receiving stolen property. The possession, 2 possessions, OREMD, the receiving stolen property, 5,000 anyway, plus EMD. The drug paraphernalia, OREMD, the unauthorized use, 1,000 anyway, plus EMD.
Grand jury date January 16, 1/16.
White.
Both cases.
Okay. What was the date?
1/16.
Just want to make sure.
Are you doing that only on the felonies or both cases? They're related?
Waive probable cause.
Yeah, I'll waive probable cause, enter plea of not guilty, Your Honor. As to bond, whenever the court's ready.
This is the only drug found marijuana?
Believe so, yes. We will defer as to bond on the felony, just asking for a stay away from all Shell gas stations on the criminal trespass.
The marijuana, felony, OR, EMD, you waive probable cause?
Yes, I do.
OR, EMD, OR, plus stay away from Shell, you said Shell? Shell on
2454 Harrison Avenue.
Stay away from Shell.
Grand jury date January 16, 1/16, both cases.
Whitehead.
Yeah, but don't worry, you have to get EMD. It's a
Barbara, you gotta get the break, okay?
Sir, Natasha Evans. Natasha Evans.
We'll waive probable cause, Your Honor.
Two more felonies and then stuck.
Jumping right into it, Your Honor, I'm asking for an OR bond. I think that's appropriate for Mr. Whitehead in this case. He turned himself in, Your Honor, when he realized there was a warrant out for his arrest. This allegation is nonviolent. It's from November. He said he got a letter in the mail, turned himself into, I guess, 2300 Ferguson Road, turned himself in, and they said that because it's a felony, he has to be brought here. In my opinion, I don't believe it's a felony. The allegation is an iPhone 12. It says that on like 5 different documents. I don't see a world where that is the equivalent of $1,100. I did some Googling this morning. iPhone 12s are about $300. Yeah, I'm just gonna say, I think the newest iPhone right now is an iPhone 19. I don't see a world where, like I said, it would be $1,100. I think if anything, this will either get ignored or come back as a misdemeanor like it should have been charged with to begin with. Also, the criminal damaging, it looks like they're claiming that he hurt the phone. That's when she reported it to the police. She reported that he stole it and then broke the phone. Like I said, Your Honor, there are some issues in this case. I checked on the prosecuting witness. She has a capias out for her arrest, so I'm not entirely sure she's going to come to court on this anyway. But like I said, I believe that Mr. Whitehead would be an excellent candidate for an OR bond. He only has one failure to appear that I asked him about. He said that he was charged with driving without a license. He ended up missing court, came back to court. He didn't have his license at that time. Then they continued it. He showed his license, and that case got dismissed because he did have a valid license. So he is working full time. He works at Heritage Bank Center. He's worked there for the last 7 years, has an excellent job there. He works in operations, makes good money there. It's actually a very interesting job. He kind of helps set things up and breaks things down. He's been having that job consistently for a long time. So like I said, we're asking for an OR bond. I think that's appropriate.
From the state. Asking for a stay away from Natasha Evans and the first remainder.
There's 3 felonies, 1 misdemeanor, 1 prior failure to appear. Looks like nothing is pending. These are from November. Supervised OR plus a stay away.
Thank you, Your Honor.
Williams.
Grand jury dates, January 21st. Both cases.
Thank you. There is a high bomber.
Request for temporary protection order. Counsel.
Okay, thank you. I'm standing in for Rich on this one too, Your Honor. Rich
What's
one
your
that
name?
is.
Antoinette Williams. I'm the mother of Mariah Williams.
Okay.
I don't know if you want to have her, you have something to say about the case?
Just that Mariah was with me yesterday when I picked her up from EMU. The new charge, it never happened. It's just an attempt as to get back.
This is a I believe she's going to sign the protective order, Your Honor. We will waive the reading of the probable cause on this matter, Your Honor.
Is Devontae Settles present?
Yeah, waive the probable cause, Your Honor. She is 23 years old. She graduated from Riverview East. She's a nurse assistant. She has one pending charge, of course, which is the basis of this, which is with the same alleged victim. She was released yesterday, as Your Honor knows, and her understanding she could go by there to get what she had per the EMD people, and I believe her mother said that she was probably there with her. The allegations, as I read them in the affidavit, state that she was not a person that hit the alleged victim in this, and she was unaware that he was even at this apartment. So she denies any knowledge or any wrongdoing. She, I think I understand that maybe the alleged victim is trying to get her fired at her job. And so there's just a lot that seems to be confusing about this case, Your Honor, but she does not have much of a record. And I would ask the court to take that into consideration, allow her to maybe keep her job, Your Honor.
Ms. Williams, take a deep breath for a minute.
I take care of my two babies alone. They got autism, bro. I should not be here. I should not be here.
We still have to hear it. All right? Just take a deep breath. I understand looking at your record that you're not involved in the system. I know this is scary, but just take a deep breath and we're gonna get through it, okay? All right. From the state.
State allows for stay away, no contact from Devontae Settles. Per the arrest report, the prosecuting witness and her stepfather, Mr. Ralph Nixon, went over to the apartment where the defendant resides in order to retrieve some of her belongings. Per this report, the defendant's stepfather struck the prosecuting witness on the head with a black handgun and then punched him multiple times. It's alleged that the defendant also struck the prosecuting witness in the face with a closed fist. When officers arrived on scene, defendant did present with bruising behind both ears and a laceration under his right eye.
Are there charges against the person who?
I cannot tell from this report. He's listed as a co-defendant, so I would assume so. But they didn't add the case number that I could reference to confirm that.
All I have is the name of Ralph.
Yeah, I don't have a co-defendant. On the do we know if box 13 was checked?
It was.
It was.
I remember this from yesterday. It was checked.
It was.
All right, so on the violation of a protection order, the bond is OR because the court allowed her to go there. Now, in saying that, there should have been an escort with her to go. And is this an EMD? Was there a jurist on this? It was straight EMD. OR EMD jurist on the protection order. On the felonious assault, while the allegations are serious, the allegations for Ms. Williams alone is a punch. The other person who is alleged to have had a weapon when that person allegedly went. The bond is $5,000 anyway, plus juris if requested. EMD plus juris if requested.
Grand jury date January 16, 1/16. Do you have Bryant
Bryant.
next? Okay. Dane Bryant. Felony, or, sorry, misdemeanor lockup. Thank you.
Good morning, Your Honor. Tess Hogan on behalf of Mr. Bryant will be entering a plea of not guilty this morning. As to bond, Mr. Bryant is a lifelong resident of Cincinnati, Ohio for 36 years. He is actively searching for a job. He has been trying very hard for the past few months, at least 3 or 4, to restart his life. He has been putting in job applications and really hopes to hear back soon. I do have good contact information for both him and his father, John. I will note that for the 25 series, there was a capias on it. He let me know that he showed up late to arraignment court. He did not understand what time it was, but he is here now. We have good contact information for each other. We'll be asking for an OR bond this morning.
So he didn't hear me say. He just showed up and left.
Yeah, I got recited right before.
On the 23rd, I believe.
December 20. No, that's when he was originally
No, I
supposed
got
to be.
I got recited Monday.
On Monday.
Yeah,
Sorry, Your
I
Honor.
called my PO and to tell him what had happened, and then Christmas and the holiday season with the court system has been out.
Where did you get your recite?
Silverton Sheriff's Office. It's right next to my house.
District 4.
From the state.
Your Honor, these are both charged as first in time, first overalls. On the one from December 25th, I have it marked as test. I'm gonna assume test refused at the moment because it's not indicated that he submitted any tests. No accident, no insurance shown. There is an ALS on that case. The 26 matter is also charged as a first, with no priors, no accident, still no insurance, and an ALS.
The OBIs. OR plus EMD plus TAD. No alcohol is a condition of bond. These are alcohol OBIs, correct?
Yes, believed to be.
OR, EMD, there's 3 prior failures to appear. No alcohol, and TAD on the minor misdemeanors. OR, the driving under, OR, EMD.
Sydney Duncan.
Thank you, ma'am.
Carlos Frierson.
Duncan.
Thank you, sorry. That's fine. Good.
Your Honor, I believe these cases may be getting dismissed this morning by the state. If I may approach.
Oh, yes.
This is a temporary protection order that you actually issued back in July of last year for a domestic violence case that was dismissed. I've attached the docket and the judge's sheet to show that dismissal. I believe it's just a clerical error that the temporary protection order was never dissolved.
State's going to be dismissed. There's no active protection order.
DR, PA, no active.
Okay, thank you.
Does the state care if this is sealed? She has no record, no failures to appeal.
Thank you, Your Honor.
Motion is sealed.
Dubs, Allison Dubs.
Got it. You go home. Yeah.
It'll be a not guilty for missteps this morning.
Does she have somewhere to go on EMD?
Yes, I have a good address for her and a contact information for someone she lives with at that address.
Is there anything from the state?
We'll defer.
OR, EMD, open hours.
Would you be open to a alternative nominal, like a 1,000 at 10%?
There's two prior. Or alternative, 1,000 anyway. Edwards.
Good morning. On behalf of Mr. Edwards, I believe I've reached a resolution with both the county and the city this morning on these matters.
As to the county cases, Judge, on the case 32716, state's expecting guilty pleas to be A and B. We'll be dismissing the remainder of the county charges per plea.
And from the city, if I remember correctly, the city will be dismissing the 2025 ticket that we'll be expecting guilty pleas to the 226 tickets.
That's our understanding as well, Your Honor.
So the entire series of 26s.
Yes, Your Honor.
All right, so that's the 166 series, 299 series, so total of 4 counts or 4 cases, and then the county 32716 A and B. Is that correct?
I believe so.
Everything else dismissed for plea.
Yes, Your Honor.
And you do understand that the 166A is charged as a misdemeanor of the first degree? I'm assuming it's because of the number of driving under suspension attorney convictions that it's elevated to an M1. Just looking at the conviction history.
I believe that it's within 2 years and within 3 years. And there's only one 45-10-16 conviction before 2022.
I don't know, I have it charged as that, why don't we send it to the trial court and they can decide it?
Okay.
As to bond?
As to bond, Your Honor, Mr. Edwards is a 27-year-old lifelong Cincinnati native. He does have a stable address where he lives with the mother of his kids, who I have good contact information for. I also have good contact information for him. Mr. Edwards was shot in the face just 6 months ago. He does have a large scar, and he is on some pain medications prescribed to him for those. For that reason, he sometimes slept over court. We have had a long conversation on how we are going to fix that. And that's why I also have contact information for the person he lives with. So if I can ever not get in contact with him in the morning, I can call someone else as well. We would be asking for an OR bond this morning as these are traffic matters.
Is there anything from the state?
I'll defer.
There are 15 prior failures to appear with, at least on a couple of these cases, a minimum of 2 recites. On the speeding, OR EMD, on 32716, on the B 250 anyway, plus EMD, on the 31930, OR EMD, on the B, on the A 250 at 10% plus EMD, tenant window violation, OR EMD, driving without a license, 250 at 10%. Plus EMD, there are 5 failures to appear. Oh no, 1, 2, 3, 5, 6, 7 failures to appear on that case. On the 32716C, 250 at 10% plus EMD. 166A is driving under suspension, 250 at 10% plus EMD. B, minor misdemeanor, OR EMD. The speeding, OR, and the new driving under, 250 anyway, plus EMD. No driving is a condition of bond. If you get caught driving, it will not be a ticket. They can revoke your bond. Are we 100% clear?
Yes, ma'am.
Until you have a license, you are not to be driving.
Yes, ma'am.
If you do, you probably gonna sit in jail.
Yes, ma'am.
Glenn,
Yes, and then this was the.
thank you.
Just for the record, I won't be submitting a designation on Mr. Glenn with the code amendment. It'll be a not guilty on behalf of Mr. Glenn this morning.
As to bond,
As to bond, Mr. Glenn does have an APA holder, so we would just be asking for a nominal bond.
from the state,
Note there is a failure to comply in 2022, felony conviction there, and then an escape conviction in 2021. Would ask for an appropriate bond given that.
there's 7 prior failures to appear. There's a parole holder, so Mr. Glenn's probably not going anywhere regardless of the bond. The drug paraphernalia is straight OR, that's M4, the obstruction 1,000 anyway, plus EMD. Goins,
The middle next to your attorney, then you got third comment. Yes, sir, Mr. Jones.
We'll be entering a plea of not guilty this morning, Your Honor.
as to bond,
As to bond, Mr. Goins is a 29-year-old lifelong resident of Cincinnati. He currently lives with his mother, Bethany, and his grandmother, who he does actively take care of with his mother. He was supposed to start work next week at Kroger, and he is hoping to still be able to start that employment. I will note these are all nonviolent crimes. We would be asking for an OR.
from the state,
State will defer. The victim on the theft is the Village of Cleves. It was a shed owned by the municipality.
$1,000 anyway, or alternative OREMD plus a stay away from Cleves Community Park. On each count. Peel.
And then the resisting is separate.
I believe Mr. Hill was waived this morning. I didn't have an opportunity to speak with him. I just asked that it's continued until tomorrow morning.
Continue to tomorrow and bond. Johnson.
Please not guilty, Judge.
Good morning, ma'am. What's your name?
Dear Conley,
I believe that's his mother, Judge.
Okay, okay, thank you. He has no record, no failures to appear as an adult or juvenile. Is there anything from the state?
Asking for a stay away from David Walker. It appears this was a iPhone, stolen iPhone.
There's no problem staying away.
Supervised OR plus stay away from David Walker. He'll be released shortly.
ma'am, there wouldn't be anything on this record that would prevent him from getting a job.
Well, this is pending right now, so this will show up. I'm not sure about. It will depend on the job, at least for right now, but this part will show up.
You go, oh, I remember that.
Yes.
Yeah.
More.
Oh, I didn't know that.
Please not guilty for Mr. Moore. As to bond, Mr. Moore does have a felony holder. We would be asking for OREMD.
Anything from the state?
We'll defer.
Or EMD on the OVI. I believe that's probation.
Yes.
Yes.
The reasonable control OR. The 23 reckless OR EMD. Driving under suspension OR EMD. And then OR on the minor misdemeanor, straight OR on those. OR EMD on the failure to stop. Morris.
Thank you, Your Honor. Mr. Moore?
Please not guilty for Mr. Morris.
Good morning, Your Honor.
Good morning. Alright. Can he do EMD?
Yes, well, Judge, we would ask if you would consider leaving the monetary capious bond at 1,010%.
That's fine. Is there anything from the state?
No.
Alright, same bond. There's a new judge than the one who put you on probation before.
Mhm.
You might want to pay the $90 restitution, because that's something that no judge can waive.
Okay.
Restitution, and that will put you in a much better place when you go see that judge.
Yes, ma'am.
Alright.
Thank you.
Simpkins,
Are these probation violations, Judge, or does she just get served these?
she,
Are these probation violations, or does she just get served these?
I don't think they're PBs.
No.
No, these are cases from
Mhm.
16. No, these are all cases.
Please not guilty, Judge.
Alright. Esteban,
Esteban, Ms. Simpkins has expressed to me that part of the reason for the significant delay in these are she was still struggling with addiction at that time. Since then, she has completed a forever recovery treatment in 2017 in Michigan. Sorry. She hasn't gotten in any trouble since. She hasn't had any contact with the court system. She's currently still maintaining substance abuse counseling with Work at Health here locally. She's been with them for over a year. She has 2 children that live with her and her fiance. They're 17 and 18. She works with Martinez Landscaping. She has done better. She's maintaining her sobriety, maintaining her counseling. The reason that they hadn't been resolved, as I said, was just a result of still struggling with addiction. She is prepared and ready to resolve those when they get in front of you, Your Honor. I believe you're the linked judge there. We would be asking for OR 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 EMD. As I said, she does have 2 children who live with her. And I'll submit on that for now.
from the states.
Defer.
Do you have transportation?
My fiance.
The bond will be EMD open hours. Ms. Simpkins will be random tested no less than twice a week. If you have randoms, you'll go over today, or whenever you're released. You'll go take your first test. If all the tests are negative, then regardless of what you all work out or trial or what have you, you'll pretty much be done with me once these are resolved.
Okay.
All right? So you'll need to come to court at least one more time with your attorney to figure out a plea or trial or whatever, but if there's a conviction and you have no positive screens. I'm done with the case pretty much, understand? All right, and then the driving law.
Thank you.
Swing.
It's over. It was. Swing.
Middle to your attorney. Yes, sir, right there, full attention, we'll return you right with you.
Morning.
Good morning. The plea is not guilty.
So you have somewhere to go on EMD.
No.
Who lives at the Fitton address?
I'm
That was my sober living house.
Was or is?
It was. I moved into an apartment with somebody, then they kicked me out of the apartment, so I didn't have an address.
He is connected with the Potter House and has a social worker there.
Yeah.
Potter House takes EMD.
I'm sorry?
Potter House takes EMD.
Okay, I wasn't sure.
But see, they don't have open bed right now. Is there any way I could just pay my bond and then go to Potter House?
From the state.
Your Honor, it does look like it's a valid 12-point suspension. Did not charge with an OPI, which is interesting. No, confirm.
1,000 anyway, or alternative EMD. Or EMD.
So I can pay the.
Yes.
How do I pay this?
Thompson.
Was that for both 1,000?
Or you did the 10 minutes. Left. Oh, wait, 10 minutes to sit down and explain all that in detail. All that in detail. Thompson. 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 Middle next to your attorney. He's right there, his full attention next to the judge.
What are the, I don't have the complaints, what are the dates on these?
Alright, as for the assault, that would have been June 23rd of 2025, knowingly caused physical harm to a Raven Ammons. Defendant was caught on video punching and kicking the victim, causing injury. No other information on that. And then for the theft charge, that was on or about June 27th of 25. Defendant took merchandise from Dick's Sporting Goods valued about $500 without the permission of Dick's.
She has somewhere to go on EMD.
She does.
There's no record, there's 2 prior failures to appear.
For those prior failures to appear, she was not represented at that time. She does have a child at home that she cares for. It's a one-year-old who she's the primary caretaker for.
I'm doing OR. It's OR EMD open hours. I just put on the record what the failures to appear.
You return a call.
Thank you, Your Honor.
Watson.
Watson.
Last hallway. OR plus MU.
For the record, he is over income, so I'll just be representing him for the purposes of arraignment.
I have 3 probation violations.
Is this Will?
Will? No,
Oh,
Watson.
sorry. Oh, sorry.
Watson, sorry.
He'll be out. He'll come out and meet you. He'll come out and meet you in a minute.
Watson, are you all looking for Watson?
I know he's upstairs in population. I don't know why.
Oh, he's not down here?
No, he's.
Okay, Will,
He was waived this morning.
so is he coming back tomorrow?
I'm not sure. I just know that he was there.
Do you want me to continue with this tomorrow?
We'll try that. I know there's TVs. I don't know why.
I'll continue these to tomorrow. Wilkes, that's our last.
Wilkes is over income.
Yes, sir. Watch feet.
The plea is not guilty.
Is there?
As to bond, you can see that there is no other, the last contact with the system was 2014, that's all traffic. Mr. Wilkes he's got his bachelor's in logistics and transport, he was.
Hold on, so let me tell you what I want to know, because this is a violation of a protection order. I need to know, if anything, stay away, where he can be.
Yes. He does have another address to stay at. He is currently staying at the Hyatt Hotel and is able to continue to afford that during the pendency of this case. He does have a French Bulldog, Winston, who he is caring for, so he needs to get home to his dog. He knows to stay away from that address. He has had no contact with the person who that protection order is for. We would be asking for an OR bond.
Defendant is to stay 500 feet away from 7699 Fox Trail Lane. Allegations are that he was parked at a neighboring house within that 500-foot radius. He has been served with a temporary protection order of domestic relations.
There's no record, no failures to appear. You understand that you cannot go 500 feet. You're going to be on Juris Monitor, which if you go within 3 miles, it will notify and your bond will be revoked and you'll be back here. Are you clear on that? The EMD for that will be open hours. OR Juris. All right, and then last case, Walkie Johnson.
Javiana Johnson.
Were there just bond? Name. You, Ms. Johnson? All right, take your hat off and then they'll come get you.
I'll work with her.
Yes.
Good lady over here, I got
Good morning, Ms. Johnson.
Good afternoon.
All right, so you paid the standard fines, which were 1,000 anyway on each, and somebody paid them, right?
Yeah.
Okay.
I'm just, I be confused about the percent. I paid it, but my mom paid it for me. I don't know about the percentage.
And there's no record, no failures to appear, and you showed up today. Is there anything from the state?
No.
All right, it'll be the same fine. You'll go get your next court date. And then at least one of these cases is a misdemeanor of the 1st degree. And it has a mandatory license suspension if you're convicted. So you should go get an attorney today while you're down here, okay?
Okay. So I wasn't supposed to plead guilty or not
Hold
guilty here?
Well, I'm entering a not guilty plea on your behalf. You'll go get your next court date and then contact an attorney, all right?
Yeah.
All right, they'll tell you where to go.
Go to room 117.
Then what's going on?